One more medals today, increasing the American lead at the Summer Games to 39. I'm Dave Anthony. This
Lawrence
is Fox
County
News.
depends on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
WDXE, that's us. It is time for Bulletproof Estate Planning with our good friend Stan Pierchoski and Pierchoski Law. How are you, buddy?
I'm good. Good morning, Jeff.
Been a whole week since I saw you.
It has been a whole week.
Yeah, been a hot week.
That it has. And I don't know, it's going to get much better, but
Not in the foreseeable few days, anyway. It looks like we're going to stay warm for a while. Of course, it's August.
that's what I mean. When it's July and August, it's hard to complain because it's kind of expected.
Yeah.
But
Yeah.
yeah, it's still you can still complain
Yes.
when it gets hot. You know, like the news folks here on the radio sometimes I guess they want to give good news about relief, and so they
Yeah.
say, well, it's going to be cooler this weekend. Instead of 97, it's going to be 94. And it's like, well.
One of my favorite comedians was kind of poking fun at the environmentalist warriors and the global warming warriors, and he said, "I got news for you." He said, "I've been around a long time," and he said, "It gets hot every summer." And then he said, "And some summers are hotter than others."
Yep. That's right.
So he said, "Just don't worry about it; it'll be all right."
This planet's been taking care of itself for
Yeah.
about, what, 3 billion years?
Yeah, that's
I
what
think,
they say.
I think it'll be all right.
Yeah, I don't think it really needs us to take care of it. It's
No.
taking care of us. That's what's happening.
Exactly. So,
That's right. That's
all
right.
right. Hey, well, we got our show today, Bulletproof Estate Planning.
Yes.
And I'm going to talk about some seminars coming up because I think last week when I was here, I didn't have the venues nailed down, but I do now.
Okay.
And but I want to make sure folks know this is a interactive show. So if you want to call in,
That's right.
feel free to do so. And 931-762
766
766-9393.
That's
See,
right.
I should have let you do it.
9393 766 9393. If you'd like to talk with Stan while we're on the air live here, we would certainly welcome that.
So we do seminars from time to time, and I have one coming up that I announced on September the 14th. So that's about a little more than a month out, and it's going to be in Pulaski. It's going to be at the American Legion, which is right there, not 2 blocks off the square. The address of that is Legion Drive. The number escapes me, but I think it's the only thing on that road. So. But you can see it from the square practically, and if
Yes.
it's if you put it into Google, just the American Legion Pulaski, it'll get it for you. And so we do that on September the 14th, which is a Saturday, and we do Saturday seminars at 10 o'clock in the morning. We call it Wills, Trust in the Nursing Home. That's what we'll talk about. The presentation is usually about an hour to an hour and 10 or 15 minutes. Then we have a pretty extensive question and answer period, which is I always enjoy that period. If you have questions, bring them with you. If you develop any during the presentation, be sure to ask. That's what it's for. I'm letting you have my time to address any issues you might have going on. Anything with dealing with your family dynamics, that sort of thing. So the next one we're doing after that is November the 2nd, and that one's going to be up in Franklin. And in Franklin, there's a place called 501 Suites, and that is on Mary Lindsay Polk Drive. I think it's 416 Mary Lindsay Polk Drive, up in Franklin, Tennessee. So going a little bit north with that one. We do that probably twice a year up there by request. We get some folks that feel like driving down here to Lawrenceburg or Pulaski is a little too far to go.
Sure.
So and I get it. But I've had people, come to my seminars that have driven several hours.
Oh, yes.
But anyway, sign up for one of those. Just call me at the Pierchoski Estate Law, 931-363-7222, and get RSVP'd. The gals will take care of you if you call
absolutely.
up on that.
And we should explain, of course, you're getting folks from all over Middle Tennessee.
Oh, yeah.
Yeah.
I mean, really, like I said, I think my record is somebody drove 4.5 hours to come to my seminar, and that
Yeah.
person came 3 times.
Yeah.
Came once by himself.
Yeah.
And then said, I'm coming back at the next one because I could never explain everything you just said to my wife. So he comes back with his wife.
Yeah.
And he came back a 3rd time with his mother-in-law and wife. And so...
Yeah. Well, if you don't mind me mentioning it, of course, I'm meeting with you later today, me and my wife, and one of the reasons is I've been sharing with her, some of our conversation, and so she'll ask me something. Well, I'm not sure how to answer that one, so I finally decided it'd be better if we just come and meet with you.
Sure. I mean, it's okay with me if it's okay with you to mention it. But yeah, we'll talk later this afternoon. And
That's right.
We'll see what we can work out. So
Yeah.
one thing I want to bring up, and something that came about, it just kind of illustrates the reason you need the plan. This was kind of it was an issue that came up. It didn't involve a lot of money, but it kind of, the circumstances make it frustrating, and it's just another good reason why we need to do something.
Sure.
Some kind of planning, even if it's minor, you need to do something. And that was got a call from the bank, and they said they had somebody there that were just wondering if there was something they could do because they had run into some issues. Here you had an individual where there was a family member that was deceased, and they had a bank account with the bank. They didn't have much money in it, $500, $1,000, something like that.
Sure.
And they were the sole owner on the bank account. They didn't have anybody else named as owner. They'd passed away. They were deceased. They did not have a will, and so the relatives, the heirs, went to the bank. How do we get this little bit of money out of there? Because even though it wasn't a lot, it was worth getting, right?
Sure.
And the problem runs into, our power of attorney doesn't survive death, and they didn't have one anyway. But so, how do we get it? The bank is not going to release it to anybody but the owner, or somebody that can stand in the shoes of the owner.
Yes.
Now, after death, the people that can stand in the shoes of the owner would either be the executor during a probate estate or a successor trustee with a trust administration. And so it was kind of like, I talked to the bank, and I know the bank can release funds like that to things like funeral home or hospital if there's balance dues. Okay?
Right.
But there wasn't any in this case, so we couldn't, or it had already been released, and this is what was left. I didn't
Right.
get into that detail, but so they asked me, is there anything we can do? And so I'm going through the options in my mind, and I know there's probate, okay, which would do it. But a full-blown probate, it costs $500 just to file it, or something like $450 or something like that, to file it. So it's pretty, it's probably going to be a wash. You're going to spend $500 to get $500.
Yeah.
And if you hire an attorney, you're certainly not going to do it. So you have to open probate and do it yourself, right?
Yes.
So then my mind sort of went to, well, what are there's several abbreviated versions of probate. And I'm going through, and one is, we talk about it occasionally on this show, but one is called muniment of title. But that doesn't work because you have to have a will, okay, for muniment of title. And then there's one called affidavit of heirship, which you can work without a will, but that's really is only ever used for real estate.
Right.
I could argue that the language of that statute addresses property, and that might work, but I don't know. Then the only thing that came to mind was small estate probate, because we have a small estate probate. A small estate probate basically is you can do small estate if the probate estate is less than $50,000.
Okay.
And there's no real estate to pass. And so
Okay.
this satisfied that, but it costs about $135 to open a small estate probate.
Okay.
And it's not that that's the big deal. So if there's like $500, $600 in this account, that would probably justify it. But
Sure.
prior to last year, small estate was something an individual could very easily do themselves. And as a matter of fact, people would come to me and say, how do I do this? And I'd say, well, small estate's your best goal. And they say, will you do it? And my response is usually, well, you can do it. You don't need to pay somebody to do it. It's pretty simple. And I just kind of give them 5 minutes of instruction on the small estate affidavit and what they got to do. It's very straightforward. So I would just guide them, and they would go do it themselves. And all you're out then is the filing fee to open it in the first place, right?
Yes.
Well, last year they changed that procedure, and it now requires a petition in Chancery Court, and so it which means 95% of people will have to hire an attorney to do that. I've not really I've used the new procedure. I think I've used it once. I can't remember. But I refer that stuff out. I know an attorney that has done that a couple of times, and so I refer it out. But I think the fee for that typically charge, I don't know, $750, $800 or something. So now again, you're in a situation where, it's going to cost more to get the money out.
Yeah.
You're going to lose money trying to get this money out.
Yeah.
And so my only suggestion, which I felt terrible because I couldn't come up with a good solution,
Yeah.
My only suggestion was, why don't you do the small estate probate and just navigate it yourself? It may be scary to folks, but it's nothing to it. The statute says you got to file a petition. Here's what needs to be in the petition. Okay?
Yeah.
And so you just put that in there, and then you file a petition when you open the estate. You have to give notice to certain people, you know what I mean?
Yes.
Then you just go in, and the court will grant you the affiant of the small estate, and now you'll take that court document and go to the bank, and now the bank will release that to you because now you're the proper person that has the authority to access that bank account. So I hope that works out for them.
Well, that causes me to want to ask some questions.
Yeah, but I'm just saying, it was, if it was $10,000 in the bank, I mean, you probably want to pay an attorney $1,000 to do the small estate probate, and it would be cost effective and it'd be worth it. But I mean, the bottom line is it sort of makes it very close to the surface as to what you need to plan, because you get your tail caught in a crack like that. There's not a whole lot you can do. Yeah. So if you do nothing, this $500 or $600 sits in the bank account, I think, for 10 years, and then finally gets turned over to the Department of Unclaimed Property. But during that 10 years, if its bank account is kind of low, they charge a service fee. Like $5 service fee.
Could get eat up.
Yeah, I mean, it's slow but sure. But so it's kind of there was a no-win situation, really.
Yeah,
and it's sad that happens. Something like that, could have been cured. If you don't have very much property like that, there's something that's referred to as the poor man's probate avoidance. And what that is you just make somebody, like some family member or somebody you trust, as a co-owner on your account.
Yeah.
That would have solved the problem.
Yeah.
Now, that can be problematic during life, so it needs to be somebody you trust.
Yes.
Because co-ownership is exactly that. If you got $1,000 in a bank account and you sign somebody to be a co-owner, you both own that entire $1,000.
Yeah, so they could go get it or use it anytime they wanted to.
That's exactly right. So there is some risk there.
Yeah.
And again, a lot of people will say, well, I trust my children. They're not going to take my money. And I get that.
Yeah.
But what happens, the way that happens, it goes south. Maybe you put your child on there, it's a co-owned account, and that child maybe goes through a divorce. And and what do they own? The divorce is to look at. Yeah. Well, they own that entire account. That could get divided that way.
Yeah. Let's see if we have a call. We may have. We'll see what's on. Hey, good morning. You're on WDXE with us.
Yes. You're kind of talking about something that I was wanting to ask about, sort of. A person has a will, and while they're alive, they have a power of attorney, financial, health, and all that. When they die, and they have a bank account, a pretty good one, who has the ability to pay until the estate is settled? Who has the ability to pay the utilities, insurance, taxes, whatever? Does that person need to maybe have a trusted person's name on maybe make a small account while you're alive, and have the person, maybe your executor of your will is who I'm thinking, name on that to pay bills and everything until the estate is settled?
Okay, good question. I think I'm pretty sure I follow.
Okay. You want to hang up and let us answer on the air?
Yes.
Okay.
All right. Yes. Thank you.
Okay. Thank you. I mean, that's a good question. Now, so we have during life. Sounds like somebody did some planning. They got a will, and they have the power of attorneys. Now, the problem with the power of attorneys is they don't survive death. Okay. Right. So now, when I say that, in my experience, there's a lot you can get away with in a small town.
Yes.
I mean, banks, when they know you and they know the deceased, they know the family, they kind of allow the power of attorney authority to continue on. Now, technically, it doesn't. It expires at death.
Yes.
So let's stick with the technical part of it. When you have the authority to act for somebody, there's like a line drawn in the sand at death. So there's before death, there's authority to act for somebody, and that is your general durable power of attorney, and one for health care. And after death, the authority resides in either you being the executor of the will, or if you don't have a will, the administrator of the intestate estate, or if you have a trust, you're the successor trustee. Okay. Now, the problem with being executor of a will, like she mentioned in this example, is you're not the executor of an estate until the court says you are. In other words, you can have a will that says, I name my son the executor of my estate, but at death, he has no authority until the court swears him in as the executor and grants him letters testamentary, which is the document that gives him authority to do stuff.
Right. That
usually happens sometime after death. You got to open the probate estate. I mean, if you do it right away, you have the power right away. That's great, as long as it's not contested. So it's a good question, and really the answer is nobody has the authority to pay those bills until you have the authority granted to them by the court as the executor. So this gentleman or this person had a will. So the best way to get these bills paid is to go to court, open a probate estate. She said it was a pretty good bank account. So so open a probate estate. This person is named in the will, will get sworn in as the executor. The court will issue letters testamentary. Now, that person can go to the bank and say, I want to take control of this person's bank account, and the bank will recognize that authority. And now that person, as executor, can write checks and pay the light bill, write checks and pay the insurance using the deceased money.
Okay.
Now, in reality or in practicality, there's a way. What you normally see is somebody passes away, but the executor's not sworn in for 2 or 3 months.
Right.
I mean, there's just delay. I mean, you got the grieving process. You got what do we do? You go talk to an attorney and say, I'm named as executor. I don't know what I'm supposed to do.
Right.
Because when you file for the will, you have to publish the will to everybody who's named in it. You got to reach out to anybody else that could be the executor and put them on notice and see if anybody objects to you being the executor.
Right.
And so sometimes some people will pay these bills with their own money.
Yeah.
But I usually advise folks, if you pay it with your own money, once you become the executor and the court swears you in, it is a perfectly legitimate state expense to reimburse yourself for things that you had paid. Because you're, like the perfect example is you can't get it the $500 it costs to open the estate. That's the court filing fee, and you can't go anywhere until you pay the court filing fee first.
Right.
And so I've seen people that will put up their own money to pay for that. Once they become the executor or the executor gets done, they can reimburse that person because that is a valid estate expense. But it can be problematic. Just like the exact question she's talking about is like, okay, who's going to pay this? And the answer is it may not be defined just yet, but it's going to be the executor. But now it's a question of when. Yeah. Because the light bill's saying, hey, we're going to turn the lights off if you don't pay the bill. And the insurance company, you don't want to let that lapse and stuff. So it can be problematic. Now, if another good argument for a trust, because when you put your property in trust at death, there's a position called the successor trustee, and that job comes to the surface at the moment of death, and they have all the power under our trust code, all the power and authority to act immediately. You ever hear about somebody pass away and they say, hey, there's people coming and going into the house and taking stuff, and and they call the police, and the police say, well, who's in authority to lock this place down? And there isn't anybody. Nobody's been sworn in as executor yet. Nobody's been appointed the administrator if they didn't have a will, and so it's kind of in limbo. But the successor trustee is empowered at the moment of death. And so they can go right into action. They can walk right into here's how that works. They walk into the bank and say, I want to take over this bank account. And the bank would ask the question something like this. They'd say, well, under what authority are you acting for the deceased? And say, well, here's the documentation that appoints me the successor trustee, and here's the death certificate to show that he's not here anymore. Right. The bank will recognize that immediately. And they'll say, okay, what do you want to do with this? And I'll say, I want to take this over, and I want to start paying bills with it. Right. And then at some point, I want to distribute it to the heirs and whoever the will says it goes to. Right. But that's a rapid way to get the power that you need to do exactly what the caller was asking about. Right. It can be done through the executor of the will. There's just usually a delay. Yeah. I mean, you could file for executorship the day after death. Yeah. People just usually don't, but you could. Yeah. So the sooner the better, because those bills are going to roll in no matter what. Right. Right.
I think you answered my question that I had while you were talking, and that is, in the instance of a executor, which hasn't been appointed yet, they could go ahead and, if they had the money to do so, pay those bills and then be reimbursed by the estate later.
That's right. I've seen that done many times, and maybe it's not the best way to do it, but if somebody has the money and they're assured they're going to get reimbursed, I've seen it done many times, and that sometimes is a quick way to get there. Right. Right. So, but those are valid estate expenses.
Well, that's yet another, example of the advantages of having the trust. And you put this in place, then you're automatically in a position to take care of those issues.
I mean, we say a trust is probate avoidance. Only a will goes through probate. Right. That's an exact example of that. At the moment of death, that person can begin to act immediately. Yeah. Just immediately.
Wow, that's interesting. That's very good. Very good.
That was a good question, and I see where somebody's mind can go there. Yeah. Because you may not think about that ahead of time, but when somebody actually deceases and they got these bills to pay, it becomes front and center.
Right,
You know,
exactly.
And it's frustrating. You go to the bank, and the bank says, well, you know, you do not have the authority to access your bank account.
Yeah. It's amazing to me, too, when I hear you talk about the time that it takes to go through probate.
Well, it can take a while. It can take a while.
Because it seems like it would happen faster to me, but it just doesn't.
Well, you know, it's all over the board what it can do.
Yeah.
There are certain waiting periods, not waiting periods, but certain periods where you have to give people opportunity. Like, you know, the very first thing up front is you'll see something in the newspaper called notice to creditors. When you open a probate estate, you know, you publish the will with the Chancery Court, and you swear in the executor.
Right.
The very first thing they do is they put an ad in the newspaper called notice to creditors. And what the statute says we need to do is we need to open up this 4-month period or 120-day period where anybody that thinks the deceased owed them money can file a claim. Now, you don't send the bill to the deceased address anymore. Once you get the notice to creditors and open the estate and swear in the executor, now there's a process. It's called the probate claims process. So you have to file your claim with the court. You know, it's a procedure. And you file it. Now, let's say you have an estate that doesn't have a lot of money in it. You sure don't want to start paying the claims as they come in, because what if you exhaust the estate and more claims come in, right? And if you have 120 days to file a claim, then a claim filed on day one a claim filed on day 120 is just as valid as one filed on day one. Yeah. And so you don't really want to start paying them until this 4-month period expires, until you see what sort of creditors are coming. You know, because if the estate's going to go insolvent because of the creditors, we have to deal with that. Yeah. And you can't pay the first ones that come in first and tell the other ones, sorry, there's no money left.
That doesn't work, does it?
No. But you know, if there's plenty there, I mean, it just depends. And but so typically, you know, I don't do probate anymore. But when I did, I would advise folks, let's just wait till they all come in. Yeah. And we'll see. And then you know, because when they all come in, sometimes, very often, you'll have a claim that is not really valid, and so the estate's not going to pay it. And if you don't pay it, that claimant is allowed to be heard if they want a hearing to explain why they think the deceased owes them money, and the estate will defend as to why they don't. Right. And that's you know, so right off the bat with probate, there's a 4-month period you got to deal with, and that usually doesn't start till a month or two after death anyway. Yeah. You know, and you really can't close a probate estate for 12 months after death, because the creditor's rights stay open for 12 months after death, which, you know, even though they have 4 months to file. Yes. They can file after the 4 months, and you have to deal with them. Now, it's an untimely filing on their part, and they're entitled to be heard as to why they filed it late. And there are certain reasons, you know. When you have a probate estate and you know of a creditor, you're supposed to let them know you opened a probate estate. It's called inquiry notice. And if you don't, then they can claim, well, they should have given me notice and they didn't. Therefore, this is not a late filed claim. And you know, the court has to hear that reasoning. And but the creditor's rights will expire 12 months after death. Now, most of the creditors know that. And a lot of times, I used to have people say, well, why don't I just sit on my hands for 12 months and then open Dad's probate estate, right? That way the creditors have all been barred now. Yeah. I get the thought process, but the law is not so simple that it just allows you to defeat somebody's rights that easily, okay? Yeah. And so what I've seen happen is somewhere around 9 or 10 months into a probate. And I don't know if there's no rule, it's just about there. Yeah. I've seen executors or family members get a letter from a creditor that says, in so many words, it says, if you don't open a probate estate, we will. Because our rights are going to expire here pretty soon, and we will open it. And a creditor can petition the court to open a probate estate and be appointed the executor. And that happens more often than you think.
Really?
Yes. And
is it just because people are just maybe, I don't know, they're just too busy to go do it, or they just don't want to go do it, just don't want to do the hassle? I mean, I guess there's a number of reasons.
There would be, you know, it's all circumstance driven.
Yes.
But like I said, if you could just not do it for 12 months and then defeat the creditors, I mean, that would be a mockery of the law in a way. Right. And, you know, so the creditors, that's not giving the creditors any rights at all if they can be defeated that way. Yeah. So, yeah. So, you know, it's it can take a long time.
You know, the thought hit me, Stan, that when our life is over, it's really not over.
Well, you know what? You've heard me say before that, if you do go through probate,
Yes.
you go to court and you open the probate estate, and what you're doing is you're creating this legal fiction called the estate of Jeff Hood, right?
Yes.
Now, that really is a legal extension of your life.
Yeah,
Not
it
your
is.
physical life, but it's
is.
a legal extension of your life.
It's life's leftovers.
To conduct life after life, right?
Yes.
To conduct the business that you
Yes.
can't do anymore.
That's right.
And
And someone has to do that.
that's exactly right. It has
Whether
to be
it's
done.
a family member or someone you have left in charge or the state, somebody's going to do it.
Somebody or one of your creditors. Yeah.
Or one of the creditors.
Yeah.
Somebody's going to do it. So that's the whole point of your conversations, our conversations here, and your practice is to help people to prepare for their estates to be handled like they want them.
And if like the caller with the question, if you don't like the answer, like the way that's going to pan out,
Yeah.
and I would imagine 9 out of 10, if not more, would not like the way that's going to pan out, and you don't want your children or your heirs to go through that, right?
Right.
You don't want them to be stuck for a couple of months and not be able to pay bills and do whatever. Then there's a solution. That's if you do a trust plan, that is 100% probate avoidance.
Yes.
It's the whole concept of the trust. Or that's one of the biggest concepts of it. It allows you to do that, and your heirs can, they're in power immediately. They can take care of business. They can distribute property. People can get their inheritance much more rapid than through, because the distribution phase of probate is toward the very end of probate.
Yes.
But you can go ahead and distribute this. Now, as far as bills that the deceased owed, those still have to be paid.
Right.
There's, you don't avoid that by having a will or a trust. But you have somebody in power to deal with that stuff immediately.
Is there any kind of public notice given when there's a trust that's going to be handled, not a will, or not gone through probate?
Not required to give a public notice. There's the trust administration phase where you have to give notice to all the people that are named in the trust that receive under the trust.
Okay.
You have to let them know that the trust is now in administration and this is what is technically coming your way.
Yeah.
Kind of let them know, and then you have to keep all the heirs reasonably informed.
Yeah.
And so
I was just thinking in terms of an unknown creditor that maybe no one's aware of or something like that. How does it even come into
Well,
play?
there's a duty on the successor trustee to determine what creditors the deceased has.
Sure.
And usually you do that by just looking at the mail and seeing what bills are coming in.
Right.
If you're not familiar with
Yeah.
people are usually family members and they sort of know, but,
Right.
You can just find out who these creditors are, and there's an obligation,
Yeah.
And creditors they have a duty to keep track of that sort of thing,
Yeah.
So as soon as they know someone is deceased and they have a valid debt,
Yeah.
they can exercise their rights and bill the estate. And again, it's the same kind of process. The successor trustee can evaluate that and decide, I don't think that's a valid debt.
Yeah. Awesome.
And I had one once where somebody, the deceased, I think a neighbor or somebody was over the guy's barn. And there was like these 4 tires leaning against the barn. He said,
Yeah.
"Hey, what do you want for those 4 tires? I think they'll fit my trailer," or something like that.
Yeah.
He said, "I don't know, give me $200 or something."
Yeah.
He said, "Okay." So the guy wheeled the tires off and didn't pay him the $200, but then passed away.
Yeah.
And so somebody made a claim.
Oh.
It said he owes me $200 because he took those tires and didn't pay me for them.
Yeah.
And they were actually able to show proof of that transaction. So that was, but it was, it was a good old boy
Yes.
swap. Here you go, take tires, give me $200, and
Yeah.
it just so happened they passed away in the meantime. But when you have a debt like that, you need to be able to show that it is in fact a valid debt. You
Yeah.
can't just make it up. Somebody could have just made that up.
Yeah.
So the estate has the authority to be discretionary with that. And of course, if you're the person claiming the debt and the state says, no, we don't think there's enough proof that there was an actual transaction, you always have a remedy to go to court and argue that. But again, when you get to court, it's all about the proof.
Yeah.
I often tell people that, when you go to court, it's not about what you know, unfortunately. It's
Yeah.
about what you can prove.
Yeah.
And, if you can't prove that it was a valid debt, it was just too much of a, he said, she said kind of thing, then you may have some difficulty.
It's kind of amazing what people will up and try to claim sometimes. I've run into that.
Oh my gosh. Yeah. You're right.
Sold a piece. I'll give you a little war story. Sold a piece of property. A fellow bought this piece of property. It had some acres, and the person that owned it previous had deceased. Well, when he got the property completely closed and bought, the neighbor to the property contacted and said, "Hey, we put a fence up together way back when with the previous owner, but he never did pay his half. Would you pay it?" And that was, I thought that's stretching it out there just a little bit.
Well, there's a it has nothing to do with the state law, but there's some statutes, but they call them like fencing statutes.
Yeah, yeah,
and it has to do with like when cows get out.
yeah,
If cows get, when you come to keeping cows in, like if you raise cows when you got a couple hundred acres, you have cows and stuff, you can be a fence in or a fence out state.
yeah.
Fence in means the cattle owner is responsible for the fence up to keep the cows in.
Right.
A fence out state, surprisingly enough, is the person beside you that doesn't have cows is responsible to put the fence up to keep the cows out of his place.
Right.
Tennessee, I don't want to say because I'm not sure because I had a case like this, but it was several years ago.
Yeah.
I think Tennessee used to be a fence out state for a long time.
Yeah.
But anyway, if now it's a point where if you put a fence up and it benefits both people, it benefits both property owners in some way or another.
Yes.
The court will enforce the fact that they have to share that cost.
Yeah.
One can put it up, but the other one can be taxed with the cost of that. So that wouldn't be that's depending on what the fence up in the first place, that might even be a valid claim. So yeah.
That's amazing.
I'll tell you a war story.
Okay.
We were doing a trust administration, and it was also coupled with a divorce. The person passed away while the divorce was pending, and we were dealing with the mother's trust. And anyway, we had some land that we were dividing, and we were gathering all the land and getting the ownership straight because we were going to give this property to some heirs, this property to the wife.
Right.
And we were trying to figure it out, and before we can figure it out and divide it, you got to account for it all, right? So we accounted for a lot of it, but there was this one tract of like 4 acres that we couldn't. There was nothing. There was like no documentation on it, and we couldn't find it. It was very frustrating. And I think if I remember, I finally talked to somebody, and the gentleman. He was elderly.
Yes.
He said, "Oh yeah, I remember that." His daddy traded the neighbor a bull for that. So think about this. Somewhere in history, these two guys are talking, right? Leaning on the fence, and one says, "Hey, what do you want for that bull?" He said, "I don't know. I'd kind of like to take these 4 acres right here of yours because they're, I don't know."
Yeah.
He said, "All right, yeah, okay. Shake hands. Here's the bull. Here's your land."
Yeah.
No documentation whatsoever.
No, nothing.
I mean, was it a valid transaction? I could argue it was a valid transaction, but it sure creates a problem 40 years down the road when you're dealing with a chain of title.
Yeah.
But anyway, we got it resolved, but that was cracking me up.
That's crazy. That's amazing.
Anyway, so you said you had a question from that thing, but I think you said it might have been answered.
Yeah, I think so. Yeah, I think I answered the question. Oh, one other thing. Yes. You mentioned petitioning the courts, and this has, I guess, we're kind of an off-cue thing here, but how would an individual and not an attorney petition a court?
Petition is a document, okay?
Yeah.
And you go to we're talking about that small estate petition. You go to the small estate statute, and it says, to begin a small estate action, you have to file a petition with the court. The petition shall include the following, name of the deceased, name of the person petitioning it, what assets are in because it's got to qualify for small estate, which means it's got to have less than $50,000 and no real estate. So you got to say, what assets are anticipated to be in and it's a long list of things. Not too long, but I mean, and you draft that petition, and it usually says it has to be averred, which means you have to have it notarized, and then you file it with the court.
Interesting.
You go to the court and say, hey, I want to open a small estate probate. They'll say the fee's $135, or something, and you'll pay the fee. They'll stamp your petition. It'll get put on one of the judge's dockets, and if there's anything, the next thing is if there's anything to be heard. Now I'm spitballing from memory right now on the new statute. They just changed that last year.
We might have missed a phone call, 766-9393, but you were answering the lady when this other call was watching the lights there. So Stan Pierchoski's on with us this morning. Of course, while we're live, we can take your phone calls, 766-9393. Pierchoski Law in Pulaski, Tennessee, but serving pretty much all of Middle Tennessee.
Well, I'm in Pulaski because you got to have an office somewhere.
You got to have an office somewhere. That's right.
I don't have offices all over the
I do have
state.
a call that may have a question for you.
Sure.
I think we do. Hey, good morning. You're on with Stan Pierchoski.
Yes, I had a friend several years ago that was motorhoming with her husband in another state from where they lived and wrote their will. She did not find out until she got back to that state. It was not Tennessee, major complications. And I thought with people moving here from out of state and people here thinking about moving closer to their children in another state, if they shouldn't make sure their paperwork coincides, not the word. In other words, to make sure they're checking on these things regardless. I'll hang up and listen.
Okay, I think I got it.
Okay, thank you, hon.
Yes, thank you. A common problem, and it's not just wills. I mean, people come with these trusts and stuff. Basically, I think she's referring to you write a will, and it's in a state other than where you reside. Now, they were motorhoming and did it while they were away.
Yes.
And came back to Tennessee. But the same scenario is if you are living, say, in Illinois or something, you and your wife or you and your spouse have a will written, and then you move to Tennessee. And then the person passes away. And so you pass away in Tennessee, and you got an Illinois will or something like that. Pretty sure that was the question.
Okay.
And so really that's not necessarily a deal breaker. I mean, we can do that. But she's right. It can be a little problematic, but it doesn't have to be. In other words, a lot of people ask me, they'll come here, move from another state, and they'll have this, I'll just use Illinois as the example. They have an Illinois trust where they have an Illinois will. And they'll say, do I have to do a new will, make it a Tennessee will, or a new trust to make it a Tennessee trust? Because the law of wills, descent and distribution and the trust code are governed by state law.
Okay.
Now, and my advice is usually you don't have to change it simply by the virtue of the fact that you moved from there to here. And the reason you don't have to change it is that in our Constitution it states that each of the states will give all the other states full faith and credit. And what that means is if somebody comes here with an out-of-state will and they pass away, you can still do the probate here. It's just administered under the out-of-state rules.
Okay.
Now that's where the problematic part comes in, and that is I've done this several times in different states. That people come here from New York, and they got a New York will. The executor's up in New York, and we open the estate here. And basically what you're doing is you're asking the Tennessee court to administer probate this will with the governing rules of the will, which is New York rules. And Tennessee is required constitutionally to give that will full faith and credit. Same thing with a trust. And so it's doable. But it can be, if you come from a state that's got drastically different rules. Now with wills, it can't be too drastically different because wills just come from the old common law. They've been around forever. Yeah. But there's where we see the different states different on wills is kind of like the laws that govern the formation of the will and making it. But as far as probating the will, it's pretty straightforward. So the answer is, and I'm kind of getting to the answer here. Yeah. She's right. It probably was a mess for somebody because they're trying to deal with an out-of-state will that they wrote once they get back here. The bottom line is it's possible to do it and not have to do a new will, but usually when that comes up, I see it's been a while since they wrote the will, or it's been a while since they wrote the trust from the out-of-state thing. Right. And when they want to make some changes anyway, and I usually advise if you're going to make some changes anyway, let's just do a new document and change the situs of the trust or the will to Tennessee. Yeah. So, like if somebody has a trust and they say, "Hey, I moved here from New York. I got a New York trust. I do want to make some changes to it, but do I have to make a whole new trust?" Yeah. The answer is you don't have to do it just because you moved. But if you're going to make some changes anyway, let's do what's called a restatement. A restatement is when you can restate the entire trust, and now including the situs of the trust or the governing law, and you now change it to Tennessee. Now, that just makes things a little smoother for the heirs later on down the road, because
Right.
now they're not dealing with the other state's rules. And you were going to make the change anyway, you know.
Yeah.
And you can do that with a will, except we don't restate a will, we just do a whole new will. But the whole new will can be done under Tennessee law. Now, some people might not want to do that because they may move here to Tennessee from New York, but everybody is still in New York, meaning their executor, the people that are getting the property, stuff
Yeah.
like that. So
Yeah.
I also have seen New York attorneys that will probate it through Tennessee. Now they'll like hire somebody like me that's in Tennessee to handle the Tennessee end of it, but they're involved in the probate, making sure that it's conducted under the New York rules.
Interesting.
I mean, it can get cumbersome, but it doesn't have to be. But again, my advice is you probably better. You don't have to change it to Tennessee, but it's probably better for
Probably
everybody in
smoother
the
and cleaner if
future.
you do.
Yeah.
Yeah.
I hate to say you have to do it and incur that expense because you don't. But sometimes you have to look at the practical matter of things and how they're going to pan out and how they're going to work after you're gone.
Yeah.
And I think that given the two, I'd just opt to redo it under Tennessee law.
Interesting.
Here's an example. You know, when we talk about power of attorneys,
Yeah.
there's one for healthcare. You know, it's like the Tennessee Advanced Care Directive.
Right.
And if you look at Advanced Care Directive, the language in there comes from the state of Tennessee. You know, it's
Right.
not, I don't sit there and draft that. It has to have certain language in it. So I get people that come to me and they spend a lot of time. They do a trust plan, but they spend a lot of time in Alabama.
Right.
Okay. And so when we do an Advanced Care Directive, I'll do a Tennessee Advanced Care Directive, and we'll also do an Alabama one.
Yeah.
Now, do I have to do that? The answer is no. Full faith and credit means that Alabama should honor the Tennessee Advanced Care Directive.
Right.
But here's what you run into as a matter of practical fact. You go into, or if, say somebody comes here from Tennessee and they have an Alabama
Yeah.
Advanced Care
Yeah.
Directive. When you go to the hospital, somebody goes in the hospital and you go, hey, I'm the healthcare power of attorney. Here's the Advanced Care Directive appointing me, and it's an out-of-state one. Now they should honor that, but the people you're handing it to are, the hospital personnel.
Right.
And a lot of times people have reported back to me that they will request them and say, look, hey, if you don't mind, here, will you fill out one of ours, a Tennessee Advanced Care Directive? It kind of has the same language on it, asks the same questions, and just fill out one of these for us. And then we'll be, then they're so used to seeing the stuff here in Tennessee.
Yes.
When you bring a foreign jurisdiction in,
Yeah.
foreign doesn't mean international, it means another state.
Right,
And
right.
if you bring in a foreign document, it makes them uneasy because when you put yourself in their shoes, they don't know if they're doing it right or not because they're familiar with how we do it here in Tennessee in our Advanced Care Directive, and I get that. Now, fortunately, in a case like that, those are very simple documents to redo.
Right.
And that's why I do one for each state because somebody says you spend 6 months in Tennessee and 6 months in Alabama, we probably ought to have an Alabama. It's easy just to have an Alabama Advanced Care Directive. So if something happens to you, you're covered wherever it happens to you.
Yeah. Yeah.
So you got what the rules say, and you got how it really works, and there's ways you can do that and just make it easier.
That is what we like.
Yep,
Making it easy.
making it easier. That's right.
That's what I like.
So I hope that answered the question.
Yeah.
But
Yeah.
again, you don't have to change it just because you move somewhere.
Yeah.
But
good questions this
But
morning.
it can be
Yeah.
easier on your heirs to do that.
Good questions.
Now,
this
she
morning.
said that it turned into a real mess, but she didn't get into the details of the actual mess. But
Yeah.
I can think of some circumstances where it would, cause problems.
Yeah, absolutely. Well, it is. They're always seeming a solution especially if you've planned ahead, which is what estate plan stand is all about.
I know. Try to be.
That's right. Bulletproof estate planning.
Yeah.
We're planning ahead and trying to avoid some of the potential pitfalls and potholes, as we say.
Now that call was actually a situation where somebody was essentially planning ahead,
Yeah.
and it didn't quite go as smooth as
Yeah.
it could have because of
Yeah.
the way it was done. So.
Yeah.
I don't know what prompted the fact to do that, whether motorhoming. When you're motorhoming, it comes across your mind that something could happen. We could both be taken out in some kind of accident.
Yeah.
And that's probably
We probably should do a will.
that was probably the
Yeah.
precipitating thought process.
Yeah.
And that makes perfect sense.
Yeah. Yeah, absolutely. Very interesting.
So I mean, and I like both those calls. I like we're giving this concept some thought.
Yeah.
And now that we're giving it some thought, it's like I think you're right. We should be doing something. Now the question is, what should we do?
Right.
What's the best thing to do? The easiest thing to do? A lot of times that's driven by family dynamics. But when you hear me talk, I'm not a real big fan of wills because of what all comes with them. I like the trust plans. I think it's one of the things that got me into this business in the first place. I think with the trust, you've often heard me say that when you do a trust, you are literally writing the rule book, and you can put in there whatever you want, and that's what's going to be enforced. Of course, absent an illegal purpose, but you can put in, how you leave the property under terms and conditions, when they get it. People think, well, when you pass away, I get my inheritance, right? Well, suppose, what if you put something in a document that says, okay, you get your inheritance, but not until you're 50 years old?
Yeah.
That's enforceable.
Yeah. Well, one of the myths that has been dispelled from me is, since I've been talking to you, is that trusts have always been kind of this mysterious thing and not necessarily for the average Joe. Trusts are for,
rich people
that, that kind of thing that, and so it's, and I think there may be a lot of mentality out there that we don't really need a trust, we just need a will. And,
I agree.
And so there's where I think the education process has come to play with you, having shows like this one. And especially even with me, I'm like, okay, well, this trust thing, I really need to look at it, and give it really serious thought.
I often say that the size of the estate should never be the deal breaker on doing a trust.
Yeah,
it doesn't matter. I mean, a trust works like a trust. It doesn't matter the property that's in it. It could be mega millions, or it could be something much more modest. It doesn't matter. Actually, if it's a modest estate, then it's a little more important that the property goes where it's supposed to go and not get consumed in other processes, right? So it, that it doesn't. That is not a criteria. It doesn't matter the size of the estate.
Right.
What the trust does is it controls the distribution of property after death, and it does so without court intervention. You keep you out of court and out of conflict, so to speak.
Yeah.
And a complete probate avoidance technique, and it does so because it's governed under a different set of laws.
Yes.
When you talk about our laws, you got all the Tennessee Code. You hear people say the Tennessee Code.
Tennessee
right?
Code, yeah.
And sometimes they call it TCA, the Tennessee Code annotated.
Right,
at the bottom of each section they have these annotations, which are like remarks. Anyway, Tennessee Code. Well, Tennessee Code, from memory, I think we've probably got 70 some titles under. Okay. So you have all different kinds of codes in Tennessee. I used to practice criminal work. You have the criminal code. You've got the probate code. You've got the trust code. You've got the motor vehicle code, right?
Yeah.
There's a whole bunch of them out there. And so the big difference is if you're in probate, and what puts you in probate is a will. And what puts you in probate with a will is that all the property you are trying to pass to somebody is titled in your name as the individual.
Right.
And the reason it can't go to that person is because you're not here to convey it. So you have to create this legal fiction called the estate of Jeff Hood.
Right.
And then now the estate can convey the property and they're going to stand in your shoes and be you because you can't do it. And so when you talk to my seminars or you hear me on the radio sometimes, I'll say anything you pass away with titled in your name, the individual, Jeff Hood as the individual, must go through probate or some version of it.
Right.
Because it can't get to the other person that you leave it to until it gets conveyed to them, and you can't convey it. But your will says where it's to be conveyed, but your will doesn't actually convey it. This executor gets appointed, and they're the ones that can convey it. Okay.
Interesting.
Now, if you pass away and you have a trust, everything's owned by you as the trustee, not as the individual. Now that triggers a whole set of different laws, which is called our Uniform Trust Code, Title 35. So that's what brings that in. That's what brings that into play. So it's a whole different set of rules.
Yeah. And so, and then then properties or possessions are basically capable of being, or you have the ability through the trust to distribute them any way the trust says.
That's exactly right. And you can be as conditional or as general as you want. I mean, some people get real specific.
Yeah.
And if you get specific, it's, if you're trying to solve a problem, it may take specifics. You often hear me say something like, if you have a drug addicted child,
Yeah.
adult child has got a bad drug addiction. Maybe you're not in that boat, but it's a worthwhile example to think about because it kind of brings to light what we can do.
Right.
You know, if you do have a drug addicted child, that's a problem.
Yeah.
And you say, I want to leave. I got 3 kids. I want to leave a third of of everything I have when I pass away with each of my kids.
Right.
But gee, on this one, you know, I could be the instrument of their destruction if I leave them a bunch of money, and they have a drug addiction.
Right.
And that's, you know, so okay, what's my alternative? Well, if I'm writing a will, my only alternative is basically probably to disinherit him. And I don't want to do that either. I love the child. I just don't love what he does.
Right.
You know, it's kind of like I love the sinner, not the sin.
Right.
Not the sin.
Right. Right.
And what you can do with the trust is you can put terms and conditions there on how it goes to him.
Yeah.
You put somebody else in charge of it. Say, look, if this can never be used for that kind of purpose.
Right.
If he ever wants to rehabilitate, it can be used for that.
Yeah.
Or it can be used if he wants to get an education. It can be used for that. But
Yeah.
somebody else is like a check valve that should make sure that this person just doesn't have money to go out and foster this habit.
Yeah.
And that's an easy one to relate to and see how we can control property. You know, the problems we try to solve are all over the place. You know, you just, as simple as somebody that just spends it all. You see, you know, if I leave this to my kid, he's going to blow it.
Yeah.
And I don't want him to just blow it. I'd like it to be a good start for him somewhere.
Yeah.
I don't know, the down payment on a house or maybe a college education or, you know, he's an entrepreneur and I think if he could start his own business, that would be great. And, this is meant for that. It's not meant for him just to go buy a jacked up truck and have a couple parties and you know, so you might want to say, all right, I'm going to give this to you, but I'm going to give it to you in a way that you just can't blow it.
Yeah. Do you have people that have a fear of the trust because they feel like they're giving up control of their assets?
Ever so slightly. Now on a revocable living trust, you don't give any of that up.
Okay.
You have complete control, complete access.
Okay.
But you know, when you hear me talk about the asset protection trust,
Yeah.
the one we used for long-term care, we do give up some access to a certain property. I mean, we give up access. We can get it a different way, but we can't directly access it. But we
Okay.
can get at it other ways. So, and yes, in that case, not often, but there are some people that just feel like they just don't want to give up that control. And I say, you know, that's the cost of creditor protection. If you don't
Right.
give up this access to principal, I can't protect it from long-term care.
Right.
And that's just the fundamental nature of property law.
Yeah.
You know, it's quid pro quo. You know, you can't just put all your property in trust and then tell all your creditors to go pack sand. You know,
Yeah.
if it's that easy, I'd be retired by now.
Yeah, exactly.
Or nobody would be a creditor, right?
Yeah. Yeah.
Well, gosh, it looks like the clock on the wall is running down.
We're
on
getting
us.
close. We ought to review the
Yes.
meetings you've got coming up before.
Yeah, the next seminar's coming up September the 14th, Saturday, 10 o'clock in the morning. Will's Trust in the Nursing Home at the American Legion in Pulaski, right there on Legion Drive, just a couple blocks off the square. Next one off in November the 2nd, which is a Saturday at 10 o'clock, up in Franklin at they call it 501 Suites. It's 416, I believe, Mary Lindsay Polk Drive, up in Franklin.
Right.
If you're up north that way, those are the seminars that are coming up. If you want to call me or talk to me about anything, you can go to my website, estateplanstand.com, or just call me at 931-363-7222. And just like these folks called in today, you know, just call and ask me a question.
Yes.
You know? So I'm not always available to take the call on demand,
Right.
but the gals will write down your question. They might refine the question with you a little bit. They'll present it to me, and I will call you back. Sometimes we'll schedule when I'll actually call you back. So
Awesome.
I don't mind. That's, you know, we're all about education. So
That's fantastic. A great visit this morning with Stan Pierchoski and Bulletproof Estate Planning. And of course, that office there in Pulaski on the square, not hard to find at all.
no, not hard to find.
Close to the Star Theater, which is you're a part of that too, aren't you, man?
I am, and as a matter of fact, August the I get in trouble for not remembering.
What's the next show?
Well, the next show coming up is an Edgar Allan Poe thing in October, and then we're doing Grease in November, which I'm
Okay.
going to direct.
Are you really?
And it's Grease with a twist, which means all the characters are going to be played by people over 30.
Oh,
So like your Danny,
maybe I would qualify.
Your Danny Zuko is going to be someone like you or me. It'll be fun. It'll be a lot of fun.
Great.
So anyway, probably got to go. So we do this every Friday morning.
That's
between
right.
8 and 9.
See you next Friday, buddy.
Sounds like a plan.
All right, man. Well, I'm in a little early. I don't know why that does that, but anyway, Stan, we only got a few more seconds. But again, the Star Theater show is going to be when?
October and November. I'll have better dates here in the next couple of Fridays.
Okay, there we go. Now we can go.
Okay, see ya.
Pittsburgh. Broadcast services of Prospect Communications.
Rising unemployment has stocks falling. I'm Dave Anthony, Fox News. The market down big a second straight day over economic